Any objection or any concerns with respect to the proposal that you file a declaration providing the last known address of your client?
In principle, I do not. I have transmitted, as the court knows, the last known address of my client to them, and that is part of the record of this court. It was done in a sworn declaration, so I believe that has been satisfied, Your Honor.
Okay. Ms. Dalton, does the state then have an objection to the notice of intent to withdraw contingent, or if Mr. Lamb provides and files with the court copy to the state his client's last known mailing address?
We do, Your Honor. Mr. Lamb also didn't provide proof of service as required under the rule that he served Mr. Eyman with his notice before serving the state, so that's not part of the record. Additionally, as you'll note from our objection, the answer is due, is overdue. He's been representing Mr. Eyman for years, and that an answer at least be filed on that. And that was the only contingency we had, is so that this matter can actually get set for trial if they're not defaulted today.
Okay. Mr. Lamb, have you provided notice to your client of your intent to withdraw?
I have, Your Honor.
The court is going to allow Mr. Lamb to withdraw prior to the court signing an order granting them, allowing Mr. Lamb to withdraw. The court will require Mr. Lamb to file a declaration with the court that includes his client's last known address.
In addition to the declaration that I filed with my, okay. Your Honor, if I may, I do represent the former officers of the committee, Mr. Jack Fagan, Mr. Mike Fagan, and Ms. Barbara Smith. Prior to the resolution of this matter, my hands were tied because I didn't know if I would have a conflict moving forward, and so I would ask, with respect to those three defendants, that the court not enter a motion of default so that I have an opportunity to confer with them as to their next step.
Ms. Dalton.
This is issues that are not properly before the court. This is all new information. You have procedures about noting and getting these matters before the court. There was no response filed to their default, the motion for default. This all could have been addressed as part of that. We don't have a notice of withdrawal for the other four political committee defendants. So it seems to me this should be taken up as part of our motion for default. But I also would object to inclusion of any information that's not actually part of a record. They're just statements made by Mr. Lamb today. They're not under oath. They're not part of a declaration. They're not in response to the motion for default.
Mr. Lamb.
Sir, I think Your Honor can take judicial notice of the fact that the state has taken no action on this matter in the 2 years since this case was filed. I can represent to the court, and I don't believe that Ms. Dalton will disagree with this because it is the truth, that I extended a CR 68 offer of judgment, I won't say the amount, indicating that the matter could be resolved. The state has taken no action in this matter whatsoever until Mr. Eyman filed for bankruptcy. So it's unclear to me, with no trial date set, what the exigency is on the state's part to act on default, but I'm happy to address that in the body of the state's motion after Ms. Dalton has spoken, if the court would prefer.
Thank you. The court's not inclined to grant a motion for default because, for a variety of different reasons, the court does not want to prejudice the defendants unnecessarily. In other words, if the court were to default, the defendants, the court expects that in a matter of a week or two there would be motions before the court to set aside the default. That's an assumption by the court, but the court's going to deny the motion for default, but the court will continue the motion for default to a date suggested by the state as early as next Friday, or perhaps the Friday after that, the 25th or the 1st, or any other Friday at the state's request. Ms. Dalton.
We'd like to have it all addressed by next Friday. Like I said, there's no way to set a trial date without answers.
The court will continue the state's motion for order of default to Friday, the 25th at 9 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
And Mr. Lamb, I'll sign an order allowing you to withdraw as counsel for Mr. Eyman. Prior to the court signing that order, I will require you to file a declaration with the court that includes your client's last address.
And does that, is it permissible to the court, since the state has that address, that that personal address be redacted since it's a public document?
No,
Okay.
because I want to make certain that there is no issue with respect to service upon Mr. Eyman henceforth. I want it to be part of the court record.
Understood. Thank you, Your Honor.
Your Honor, can we also have a requirement that, as required by the rule, that there's proof of service of the notice of intent on Mr. Eyman? That's also required under the rule.
Yes, so include that in your declaration as well.
Thank you, Your Honor.
Okay. State of Washington versus Tim Eyman et al., 17-2154634. Mr. Ard, good morning.
Good morning, Your Honor.
Court called this matter. The court will allow, Mr. Ard, do you have any objection to?
I have none, Your Honor.
Thank you. The court will take up at this point only the issue of Mr. Ard's intended withdrawal. Mr. Ard.
Thank you, Your Honor. As we discussed with the bankruptcy court yesterday, there's a chicken and egg problem here. I no longer have an attorney-client relationship with Mr. Eyman. I noticed my intent to withdraw. The state objected to it. The two procedural objections were not noting the trial date and not noting Mr. Eyman's address. I can do exactly the same thing in this matter that Mr. Lamb is doing in the other one, and put in a declaration with that address. I can represent to you that Mr. Eyman does know my notice of intent to withdraw, that the state has all the documents that they've asked for. They know the trial date, they know his address, and that the bankruptcy court is awaiting your ruling on this to allow me to file a notice of intent to withdraw in the bankruptcy court.
Ms. Dalton, the court will allow you, in fact, ask you to place the state's objection on the record, if it hasn't, of course.
As noted, we had several objections. This notice of intent to withdraw is not just to one defendant, it's to two. Mr. Eyman is not the only defendant that Mr. Ard appeared and represented on November 30th. The bankruptcy court yesterday granted him counsel status, special counsel status, to represent the bankruptcy estate in this proceeding, and he needs an order from them to withdraw from that status. So to the extent that Mr. Ard believes he's getting out of this matter entirely, he can't without an order from that court. With respect to the specific Rule 71 deficiencies, there's no proof of service, again, on Mr. Eyman, which triggers then the 10 days for the notice to any other party. He has to serve first, and then the 10 days begins to run. Number two, he didn't include an address on the actual notice for either Mr. Eyman or Watchdog, so that's a deficiency. We still don't have an address for which to serve the other defendant, and quite frankly, allowing him to get out as to that defendant leaves that defendant unprotected, because Mr. Eyman can't represent that defendant. It has to have counsel in order to participate, and that leaves it vulnerable to simply a default in this case, especially with contempt sanctions running against it every single day. Number three was not the notation of the trial date on the, those are the technical deficiencies with the notice, but in addition to that, when Mr. Ard stepped into this case in November representing Mr. Eyman, he knew at that time that discovery cutoff was set for December 14th. We had many depositions, many subpoenas to return, third-party subpoenas to be returned on, and several motions. He came to you on the 14th. He was aware of it at the time that the case was temporarily stayed. They didn't argue for any additional time. As soon as the bankruptcy court ruled on the state's request that it confirmed the state's position that the exemption did not apply, or the automatic stay did not apply to this proceeding, You had an automatic trigger date. No one argued against the period of time. And all the state has done now is renote everything now for depositions, at least for the third time. So to the extent that there's an attempt to get out of this case at this point, it's even further delay that's being generated by Mr. Eyman's conduct, and we would ask that he be required to stay because the court has the authority under the case law, and had we had an opportunity to brief you on that, we would have. You have the authority to keep an attorney in even if they don't want to be. In this case, the bankruptcy court has already said that Mr. Ard will be able to submit his fees. He will not go unpaid for his work on behalf of Mr. Eyman and Mr. Eyman's bankruptcy estate. So we would, those are our objections, and we would request that you keep him into this case until discovery is completed. Right now, under your order, that date is February 12th.
Thank you. Mr. Ard?
Yes, Your Honor. The state's objection to my compensation in the bankruptcy court is continued, by the way. So that is, as yet, no guarantee of compensation. That, however, is not the issue. No court rule and no notice, no bankruptcy court rule creates an attorney-client relationship where none exists. And so none exists. I notice my intent to withdraw, and I don't believe that the court can compel me to remain in a case on behalf of a client who's not a client. There's no attorney-client relationship. And so that's the basis of the request to withdraw at this point. And nothing the state has said changes that fact. As to Watchdog, it was a single-member LLC, Mr. Eyman the only member. That was administratively dissolved at the end of last year in accordance with state law. I mean, if it defaults, it defaults, but it's a non-existent entity with no assets and one former member. I'm quite sure the state can depose the former member of a dissolved LLC, but I can't represent that former member because there's no attorney-client relationship. And so fundamentally the issue here is that the time span of the withdrawal doesn't alter and doesn't create or perpetuate an attorney-client relationship where none exists. And so of all the things the state is asking the court to ask me to do, I am professionally and ethically constrained from doing them. I've said that to them, gotten no response to that, but I cannot, consistent with my professional ethical obligations, remain in this case and continue to purport to act on behalf of someone who is no longer a client.
Nor am I going to require you to. I'm going to require that order that you sign a declaration, file it with the court, includes Mr. Eyman's last known mailing address and some declaration of service from you that you have provided notice to Mr. Eyman of your intent to withdraw. And then contingent upon or assuming that you do file such a declaration, I will sign an order allowing you to withdraw as attorney for Mr. Eyman.
Okay, so I will give you those in practically identical form to the ones that Mr. Lamb has filed. Thank you, Your Honor.
And then as to Watchdog, Your Honor? Because
I'm not going to take any action on Watchdog today because it's not before the court. There isn't a motion to withdraw on Watchdog.
I believe I noticed my intent to withdraw as to both, Your Honor.
Oh, you did? Then
believe so,
I
yeah.
stand corrected. Give me a moment because there are almost 800 pleadings in this case, and it'll take me a while to get there. Scroll down.
filing date was January 7th.
Thank you. What does it say, Ms. Dalton?
It says both defendants.
I'll grant the motion as it relates to Watchdog contingent upon
Same information.
same information.
Thank you, Your Honor.
Then I'll take up the substantive matters after the court signs orders allowing withdrawal. That'll be a while. A number of other cases in there.
And you expect to sign those this morning, though?
I do.
Okay. Mr. Lamb provided me both of his notice that he's filing with the court that you expected before executing his order, as well as the order I reviewed and signed it. Mr. Ard showed me his order, but not the declaration and notice that was being filed, so I haven't had an opportunity to see what's in that. And to ensure that it includes contact information for both defendants. The only other question with the tougher to raise taxes question, I'm assuming we don't need to renote it, that will just be handled by the clerk's office,
Yes.
getting it on the calendar for next week?
It's on the calendar for next week.
Great, thank you so much. This indicates Mr. Eyman's last known address, but it doesn't indicate my contact information or watchdog.
Mr. Ard, is there contact information for Watchdog? I understand that's a defunct.
And Mr. Eyman was the sole member of the LLC, so
Okay.
to the extent a dissolved entity has a contact address, it would be the last member.
Okay, why don't you include, if you were so inclined, that Watchdog Inc. may be contacted via Mr. Eyman at the above listed address.
It's an LLC, and there are dissolution laws that apply to how that works, so
Okay.
while they may have dissolved it, it's not, it cannot get rid of this proceeding.
Understood, yeah, I'm aware of some of the
Okay.
case law as it relates to that particular issue.
Perfect, thank you, Your Honor.
State of Washington versus Tim Eyman et al., 17-2154634. Mr. Eyman, good morning. Wherever you like. Ms. Dalton, good morning. Mr. Sack, good morning.
Good morning.
This matter comes before the court. Three motions. There's a motion for presentation of an order. There's a motion for leave to file an amended complaint, and there's a motion to revise the order from the special discovery master. First, with respect to the presentation of order, Ms. Dalton, Mr. Sykes.
Mr. Sykes,
Yes.
Good morning, Your Honor.
Good morning.
So it was almost 2 months ago, November 9th. I don't know if you remember, but so we had a motion up on that related to Watchdog and the application of the Fifth Amendment as to Watchdog. And your ruling was that that Watchdog did not have a Fifth Amendment privilege, and that even though Mr. Eyman did, and that they needed to respond to the discovery and to certify the responses that you previously ordered. So the order we prepared reflects that ruling that you made on November 9th.
Okay. Have you showed that to Mr. Eyman?
I had not, I showed it to the previous counsel.
Okay. Did previous counsel sign off on that?
They did not.
Okay, why don't you show that to Mr. Eyman? Mr. Eyman, do you have any objection to the entry of that proposed order?
I don't even know how to answer. So,
Yeah, I don't recall one way or the other whether you were here or not, frankly. I mean, no disrespect to you. The reason I state that for the record is that if you weren't here, you wouldn't have any way to respond to what is being represented by the state. But Mr. Sack, why don't you hand out that proposed order for the court's review? Your signature. And the court has signed the order.
Your Honor, may I address the court?
Yes.
So I am here obviously representing Citizen Solutions LLC and Mr. Agazar. My purpose here was only if the court had any questions about the coming discovery calendar. I don't represent Mr. Eyman in this matter, and I was going to enter this order and then exit, but I wanted to know if you had any questions about the pending discovery for us.
I don't.
Okay, thank you, Your Honor.
Okay. Motion to amend complaint. Ms. Dodd.
Good morning again, Your Honor. Linda Dalton representing the state of Washington in this particular motion. It's a motion seeking the court's leave to amend the state's complaint. The facts are set out pretty cleanly, and this court has probably dealt with a number of these types of motions, so I'm not going to belabor the case law on it. Obviously, this motion was filed back in November. Now, 2 sets of attorneys ago. It was noted and was scheduled to be presented to you early December. That matter got set over as a result of Mr. Eyman's bankruptcy filing. As soon as the court there ruled, we renoted it, and you have it today. So Civil Rule 15 applies and provides that amendments should be freely given when justice so requires. The basis for this modification is the fact that once the state actually got some discovery requests and documents from Mr. Eyman, identified additional violations under the Act. The trial is more than a year away. It's January 27th of next year. So the criteria that the court looks at under the case law about whether to allow an amendment, you look at issues of undue delay. Obviously, with a trial more than a year away, there isn't any delay. There was no delay that would have negatively impacted any of the defendants here by the state's bringing of the motion. Unfair surprise, obviously, this information came directly from Mr. Eyman's own records, so he would have been aware of all this information at the time. And then remoteness of issues. Frankly, these claims are just the same statutory violations, the same allegations of statutory violations, so over a greater period of time. Your Honor has heard a number of times from the defendants, it's just 2 violations, it's just 2 violations. Well, the information and the evidence that's been gleaned now shows that it's not just 2 violations, it's additional years. So the state is seeking your permission to amend its complaint. There's no prejudice that has been demonstrated that would affect any of the defendants on this issue. There was no response came from the Citizen Solutions defendants, no objection there. And the response that was filed by Mr. Eyman, quite frankly, didn't really address any of the criteria that the court reviews in determining whether to amend a complaint, any of the standards that the court is looking at. So we're asking that you allow the amendment of the complaint, and at which point we will file and serve it.
Thank you.
Thank you.
Mr. Eyman.
Your Honor, Tim Eyman, pro se. There's no reason you would remember that 7 years ago I came before you on a pro se motion concerning the Attorney General's office on a description of one of our initiatives. And I was pro se. I was before you. I read from a sheet of paper what I wanted to say.
You're incorrect. I remember that.
You do.
Vividly.
I lost.
There's no such thing as winning and losing in court parlance. From a litigant's perspective, I understand that term because people believe they win and lose. But
fair point. Fair point. But I, sitting there at that desk, I said, Your Honor, this was an interesting experience, but it's one that I will never do again. And
I remember that.
I was pro se. I was taking care of it myself because the stakes weren't that high. So when it comes to what's happening here, the stakes are extremely high. So the state has asked for the motion leave to amend in order to expand the case. The only thing that's in their brief that I would agree with is if you don't grant it, then they'll just come back and do another one. So I have sought to, in my brief that I filed on Tuesday, to,
Let's take a break. I want to take a break.
I'm not sure if it's going to make much difference.
Well, I want
Fair.
I want everyone to have an opportunity for it to make a difference. These are difficult issues. It's difficult for everyone. So let's take a break. It's 10:12. I'll go back on the record at 10:20. Court's in recess until 10.
Thank you, sir.
Thank you. In the interim, if there are any ex parte orders I can sign, I'll sign.
We're ready, Your Honor.
Okay, why don't you bring up the order?
Thank you very much for entertaining this before the recess, Your Honor.
Yeah. Time is off the record, Captain. Time is money. Mr. Eyman, please continue.
Your Honor, Tim Eyman, thank you for that opportunity to compose myself. You said something at the end that I don't think is correct, that this isn't easy for anyone. As I struggled to be able to compose myself, I saw the very people that were prosecuting me laughing and giggling and having a great time. And the reality is they have nothing at stake because they have an unlimited supply of money. They have the ability to bury me. They already have. They've reached the point where I did have to file bankruptcy because of the escalated costs. I tried to keep up with it as best I could. I asked people for help. And now the fact that I asked for help is being used against me because how dare you ask people to help, because they were asking for so much money, money I didn't have. The only way I was ever going to be able to keep up with it was to be able to ask people for help. They're saying those are political donations that I received. The only way you can buy that argument is to say that this is a political lawsuit. And I don't think the state would concede that this is a political lawsuit. The people that helped me did so because they thought that it was unfair what was happening. And they listened to me ask them to help me in any way they could. I sincerely believe that if we ever got to the end and you made a decision, I think I would get a fair shake. But it seems the goal is to make sure we never get to that point. To make sure that we never get to the merits, never get to what the underlying issues are, and that instead it is the process itself will be used as the punishment. And it is a struggle for me to sit silent as attorneys that I hire, people who are smart, that know the rules, are being told by the state, you didn't do that right, you didn't do that right, you didn't do that thing right. I saw email exchanges between Joel Ard, one of the most brilliant attorneys in our state, over about 3 days, where they pointed out all the things he was doing wrong. And I think to myself, if Joel Ard, in the state's view, is not competent and can't understand the rules that are laid out, how can I possibly hope to be able to do that? I know the state comes from the perspective, and it sounds so reasonable. If you just followed the rules, you would have no problem. The problem is that in the legal system, there are so many rules. I was stunned when you said earlier, well, there's been 800 pleadings in this case. And my jaw dropped, because the reason you hire attorneys is that you have no idea what's going on. And imagine yourself in my position going, all my life, for the last 20 years, I've relied on people that are professionals to advise me to make sure that I'm following the rules that are laid out. I've done that, and now in the legal system, I'm relying on the professionals to make the best arguments they can, and I follow their advice, and yet, somehow, with these people that know what they're doing, I'm in contempt, I'm told that I'm not complying, I'm not cooperating, and I'm just along for the ride because I'm doing whatever I'm told to do, but I'm also being told throughout that process, you have to understand, Tim, the rules seem to keep changing, and you don't have the resources to be able to appeal a lot of this stuff that they're saying because they can outgun you, they can outdo you, and you simply cannot possibly keep up with it, but we're doing the best we can. On November 21st, you made a ruling, I believe it was 4 times, my attorneys tried to get me purged of contempt. And I hear that your ruling was, he's done enough, he's out. But the ruling was, your LLC is not, because you have to sign the bottom. And that's when I broke. I completely broke the following day, because I said, what is going on? I can't possibly keep up with it. So it was at that day, November 22nd, where I first thought bankruptcy. I didn't know how it worked, didn't know what it was. And I always thought bankruptcy meant you're out of money, you're gone. And I learned that I wasn't bankrupt by that definition, I was insolvent, that my assets couldn't possibly keep up with the liabilities in the case, where the state is asking for a $2.1 million fine, which I certainly don't have, and they get awarded investigative costs for doing the very prosecution against me if they win. So on November 22nd, I made the decision to pursue bankruptcy. The day I signed the papers, I asked the bankruptcy lawyer, is this really my only option? And he said, I cannot believe you didn't do this sooner. So I'm out there, I'm scribbling down stuff and trying to keep with it. Back to the point, I had hope when Joel Ard agreed to represent me that I had a shot at continuing to fight this. And when I heard the state argue in bankruptcy court that he wasn't competent to be able to represent me, and several days later, after prevailing and getting him off the case, the hardest thing I ever did was to instruct him to go to the state and say to them, what do you want? What is it you need? What is it? What is something that I can agree to that will end this? Somebody in my position would not do that without getting counsel from my attorney, but obviously only hypothetically. Such counsel would say, you're without counsel. If the state can object to me representing you, they can argue against anybody and will. So you have to be open to that.
The day that he sent that out, the response from the state wasn't just no response. Their response was a bombardment of emails, motions. It was an overwhelming message, I took it as, that under no circumstances, no matter what we offer you, if we offer it to you, there's a danger you might say yes, which would actually end it. So therefore, we can't verbalize the response. The only response that has been given now is in the Everett Herald today, only to the media, not to my attorney at the time. Instead, it's 10 or so days later, their only response is, it's Mr. Eyman's fault. He's not cooperating. We need to continue the investigation. They have now my tax returns going back God knows how long. They know exactly. They have all my bank accounts. They said that wasn't good enough. We want the individual transactions. Now in the midst, they have all the emails that we went through. And I have to say this because it's a struggle to even acknowledge this, is that I didn't go the Hillary route and just took my hard drive and computer and bleach it. I did what they said, mirror your hard drive, but then somebody in my position would say, if you were represented by somebody, they would probably say, you can't turn over every single document on your computer. The state doesn't have right to all of that. Therefore, we have to go through it. So, before anything could be turned over, it had to be reviewed. In the midst of the state doing some of those 800 motions, making it impossible for representatives of me to be able to keep up with it all. And what drove me crazy is in every single motion, Mr. Eyman is not doing this, Mr. Eyman is not doing that. Tim Eyman was sitting back and letting the people that he hired handle it as best they could, given the resources that I had available. I said to myself, why is it I'm being blamed in all these briefs when I'm relying on people that supposedly know what they're doing? And I said to myself, it's not because they're incompetent, it's because nobody can possibly keep up with all the demands that were involved in a case that is so disproportionate to any other complaint that's ever been done. The motion before you is leave to amend. On Tuesday, I tried being pro se, because I didn't know what I was doing, is to say, can you give me some time to get an attorney to represent me? I'm disadvantaged by the fact that I can't just go out and hire an attorney. I have to hire an attorney that is eventually named by the bankruptcy judge as being acceptable. Effectively, the only creditor in this case is the state itself. The state, being a creditor, has the ability to be able to object to whoever you hire. And based on what has been done previously, when I asked for a delay so that I could get counsel, the hope, the belief is that you will recognize the impossibility that I have, which is it can't just be, just go find replacement counsel. It's not that simple, because in bankruptcy, which I did not do to try and stop anything, I did bankruptcy because I could not afford what this was costing. The idea, if anybody understands bankruptcy, it is a humiliating experience where you are on the line and they examine every single transaction moving forward. You have to report it all, you have to track it all. And the idea that you would do that for the purposes of, well, it's just so you can delay things. Delay only costs me money. It does not cost the prosecutors a penny. It makes no sense whatsoever that somehow I'm dragging this out because I'm the only one who's being hurt by the delay. When this thing was going to be in November of last year, my attorneys opposed that change because it was conveyed to me that maybe we can make it and actually get before this judge in November. When the state managed to get this thing pitched to January 2020, I absolutely lost it because that delay did not help me. It only cost me more. I had a shot to get in front of you. I had an opportunity to be able to highlight the flaws, the bogus interpretation of the law that they're doing here, to say that things that were put in the brief explain why what they're arguing is not true. I believe that everything I did was consistent with the law because for 20 years I've spent an enormous amount of time making sure to check in with my accountant on what is required and what is not. And I followed that advice. Is it possible that my accountant doesn't know what the rules are? I guess so, but I relied on him because he knew the rules, he knew how it worked, and so I followed the rules that I was told to do, which were consistent with the law as it's normally interpreted. To summarize, sir, and you've been very patient, and I appreciate it because I have to vent because I feel like I've been bottled up for 6 years and I can't talk. I'm in bankruptcy court, I'm standing up, and the judge says, "You're represented by counsel." I said, "Effectively, I am not. The state is objecting to my bankruptcy lawyer, to my divorce attorney, they're objecting to my tax attorney, and they're objecting to the attorney that I wanted to hire to represent me in Thurston County Superior Court. I'm effectively without counsel." He said, "No, you really are. Larry Feinstein is your attorney." And I said, "No, he's not." So I'm standing up, he goes, "No, you can't talk." And it seems like a perfect metaphor for what this lawsuit is about. Let's make sure that Tim Eyman can't talk. Make sure he can't express himself. Make sure that he can't actually get people to be able to help him do political action. So, to say that I'm frustrated is an understatement. To say that I feel that this is unfair is accurate. And based on the rules of the court, I haven't got a doubt in my mind that I did not file the paperwork properly to get a delay. I started writing that brief on Saturday at 6 o'clock at night until Tuesday at 12 noon. It was nonstop, doing my best, and I hope it's readily apparent that I had no idea what I was doing. But it was the first time that I had a chance to say that what they've said I've done is wrong, that it's not true, that it's a pure fabrication, that it's a twisting of the law that doesn't apply to anybody else, that's never applied to anybody before. And the idea that since 2012, since this thing started, that me asking people for help so that I could survive what was clearly going to be so expensive I couldn't possibly keep up for it. If I hadn't asked for that help, I simply would have been bankrupted earlier. There was always a chance, every step of the way, if I kept fighting, if I kept trying, I might get to the end where I'd actually get an opportunity before you, through counsel, to be able to argue the merits of the case. There were some early motions, partial summary judgment, to say to the court, Your Honor, can we at least look at the merits of the lifetime ban on political activity? Because it's ridiculously unconstitutional, it's wrong. Can we look at whether or not Tim Eyman was the treasurer or not? Because he clearly wasn't, and wasn't responsible for the reporting. There were multiple opportunities to be able to do a partial summary judgment, to be able to get to the merits. The state opposed it. And they said, we need to do all that stuff after discovery. When they got that green light, it became apparent to me that they recognize that on the merits, what they're arguing is almost laughable and makes no sense and is inconsistent with any of the laws that are out there. Therefore, we have to get an effective lifetime ban, effectively stop him from being able to do initiatives by destruction through discovery. We are going to absolutely find every way to be able to go after him and ask for everything conceivable. And when we get that, we ask for more, and then we ask for more, and we move the goalposts over and over and over again so that it's never, ever, ever enough. And now it's reached the point where they want to start interrogating my accountant. They want to interrogate some of my top supporters. They want to go after, they want to be popping all over the country, spending taxpayer money. Not that I am impacted by that, but it does seem like this is somewhat disproportionate, to say the least. And so when it comes to the motion to amend, I opposed it. However, if you would accept the opportunity for me to at least try to actually obtain replacement counsel, I would withdraw my opposition to that. I'll take it today, I'll be served today. If I have to sacrifice that in order to just be able to get some time where I can actually get an attorney, not just to agree to represent me, but to get one that can make it through the gauntlet that the state has now set up, where they get effective veto power over anybody that I would ever bring forward. So for the last period of time, no other attorney could represent me because I was sort of represented by counsel. So I couldn't even ask them or communicate with them in any way, in any substantive way, and so I really couldn't even ask them whether or not they could even consider taking over. Now that Joe Lard has withdrawn, now that Mark Lamb has withdrawn, or are no longer representing me, however that was done, I am now pro se. I am before you. I told you 7 years ago I'd never do it again, and I'm not here by choice. I'm here because I've been given no choice. I didn't realize that bankruptcy gave the sole creditor, the old law firm, $77,000 I own, the state is the 98% 8.3% creditor that I've got in the case. I didn't run out on credit card debt. I didn't run out on a house loan. It's only because of the state that I had to declare bankruptcy. Now that I'm without counsel, my deal is on the table. I would appreciate it very much, sir, if you would delay discovery. The case is not going to be heard for another 11 months, which I was not in favor of. I would request for that delay, despite the fact that I probably didn't file the paperwork correctly. And if I have to sacrifice something in order to get that, the only thing I know is this is the way normal people talk. I will give you something in exchange for something else. In the legal system, I don't know if it works that way. So the motion to amend is better than them coming back and doing it with a new lawsuit once this one's over with. So if that's what it's going to take in order to get a delay, which gives them carte blanche authority to be able to target people whose only thing that they did wrong is that they helped me, and it's done for the purpose of making sure that I can't continue. I'm isolated, I'm left without the people that I was the closest to, so that I can't communicate with them. So none of them, forget about political stuff, would not even want to associate with me for fear that it simply would draw them in, have to lawyer up, and have to go through this process with subpoenas and depositions and all the things that have been thrown at people whose only sin was that I asked them to help me and they agreed to. But I haven't got a doubt in my mind they'll pursue people that didn't help me, but that I asked them to help me. Honestly, Your Honor, they argue that it's a political contribution if people help me because I'm a full-time political activist. Ergo, because you're a full-time political activist, anything that you do, all your transactions in your life, indirectly help the political action that you're pursuing. Therefore, it's an in-kind contribution. So therefore, it has to be on a campaign report. Or, Mr. Eyman, you register with the state as a political action committee yourself, which I can't serve as treasurer as because I agreed 16 years ago to not serve as a treasurer, so how the hell that would work, I would have no idea. But I would register and on a monthly basis report everything I receive and everything I spend. As you know, the Fair Campaign Practices Act does not say that a political action committee only reports the money coming in, it has to report how it spends it. The state would say, I don't understand, Mr. Eyman, you know the rules. These have never been the rules ever for anybody under any circumstances. If that was the case, my accountant would have known it and he would have told me that. But I keep saying to summarize, but you said this is not easy for anyone here. It is extremely easy for the other side. They think it's funny, they're enjoying it, because they think it's hilarious how they've managed to get people to believe that I'm trying to stall things. I'm trying to slow things down. I'm trying to obstruct what they're trying to do. I don't think, I think the only individual that it's not easy for, well, I think it might be for you too, but me, is that this is extremely difficult because I'm in a position to have to defend myself without counsel And I didn't fire anybody, it's just that the people who were prosecuting me effectively found a way to make sure that I didn't have any. And I want to try to obtain counsel. I want to try. There's always a possibility. As long as you keep trying, you might be able to prevail. But if you throw up your hands and give up, you can't possibly do that. So I would like the opportunity to try. If I have to file some motion that I wouldn't know how to file, to have this heard next Friday, because it sounds like I'm coming back here for that, we can do that. But there are depositions next week. They're stacked on top of each other. My interests are extremely implicated in everything that's asked at those depositions. If I had counsel, that counsel would be at those events and those depositions to be able to know what's going on. And they would know what they're doing. And if I'm pro se next week with depositions, let's see if I get it right, Seattle, Vancouver, we're off to Virginia, then we come back and now we're in Spokane, and we're going to do this over, I think, 7 days. Even if I could do that, I wouldn't know what to even be doing. What these people are going to be asked is, did you help Tim? They're going to be asked, did you help him? Yes. Why did you help him? Because I like him. Because he asked me. The state will then follow up and say, do you like what Tim does politically? Yeah, I like what Tim does politically. And then it's over. They will then argue admission from this person that it was a political contribution. The people who helped me did so voluntarily. I didn't put a gun to their head. I did it, and I asked for help because I knew how expensive this lawsuit was going to be. I knew I did not have the money to be able to keep up with it myself. I knew that at some point there would be some kind of judgment against me, and so therefore I had to ask for help, and I couldn't just sit around and wait for the eventual judgment before I asked for help. If I did that, I never would have been able to be standing before you now, because there never would have been any attorneys that I could afford. At least I managed to make it this long to be able to at least be before you now. But as I put in my brief, my legal defense funds went to zero on the day that I was in bankruptcy. This entire process is just, it's taken it all. Now, I'm sure they now want my house, I'm sure they want all sorts of stuff that I've got, but the punishment should be proportionate to what you did wrong. In this case, I don't think I did anything wrong. I think I did everything correctly. I adamantly deny everything that they've said, but it seems so over the top to think that, aren't we there now? I loaned $500,000 to a political action committee by selling off my retirement fund. What is the likelihood I'm ever going to get that money paid back? Almost zero that I'll ever get that money back, because it's part of the bankruptcy stuff. What is the likelihood that I can actually earn a living moving forward, given what they've done to me for the last 6 years with press releases and just slime and sleaze and innuendo? And I am broken by this, but it seems like they say to themselves, but he's still moving, so we gotta keep going until he stops trying. I will never settle with them based on what they did with the last settlement, where I said, I'm open to considering what you've got to offer, and what they had to offer was 10 days later to a reporter saying, no, we have no offer. I can, however, accept your judgment, deciding based on the law, based on its normal interpretation, based on proportionality to how the AG's office treats people of different political persuasion. Whatever that financial judgment is that you would impose, I think would be reasonable and fair. And if you told me that because I've decided that what you've done over the last 6 years means that you have to no longer be politically active in the state of Washington, I would accept it, I would abide by it, and I'd hate it, but I know there's absolutely no way that this Attorney General will ever agree to a settlement that is reasonable. The last time I agreed to a settlement with them, I agreed to a $55,000 fine, which back then was really high, after spending $70,000 on attorneys, and I agreed to never serve as treasurer for the rest of my life. I was 35 years old. My lawyers said, breaking attorney-client privilege, this is insane. They want you for the rest of your life to never be a treasurer. You mean to tell me that when you're 70, when you're 80, you can't serve as a treasurer for some school bond or something? This is crazy. I said, I want it over with. I've spent $70,000 on you guys. $55,000 is crazy, it's nuts, but it's awful, and it's unfair, but I'll agree to it. And it's almost like, and it's exactly like, Bob Ferguson, the chess master, looked back on that agreement and said they made the wrong move. What they did was they settled. What they did was it was mercifully over in a year. What they did was they accepted what he did, and looked what happened. He survived. He came back. He kept going. He kept moving on. He survived it because we settled. Because they settled, he was able to continue. This time, this case, he seems to have said, we have to make sure that it's not merciful. We have to make sure that the process is the punishment. We have to make sure that we're going to make this thing last as long as we possibly can, because we know that we can outlast him because we have an unlimited supply of money. The metaphor I've used often, and I don't like it because in this metaphor I'm the Soviet Union and they're Reagan, but it is like the arms race in the 80s, where Reagan knew that the Soviet Union couldn't keep up with his spending, so he spent so fast that they couldn't possibly be able to keep up. And he broke them and ended up being successful. In this case, in a fight where the only money I've got is the money that I have, which isn't a lot, based on what is in every document that everyone will look at. They've got my tax returns. They know how much I'd made. And from 2012 on, it was simply an effort to be able to keep up as best I could with the arms race that I was in against an entity that had unlimited resources, was willing to overspend their budget dramatically solely on this one case. It is a classic sledgehammer hitting a gnat. It is so disproportionate and so over the top. 800 pleadings. It is truly insane what has been happening. Your Honor, I think I would get a fair shake from you if I can get there, if I can actually get to the merits. If we're going to get to the merits, I'd like it to be with counsel. I think counsel would do a better job than I would representing me, and I would like the opportunity to be able to pursue that, to do my best to get one, and if you would grant me that delay, I would not oppose them amending the complaint so that there isn't a second one later. The state was correct on that. Why? Comical. Because why waste state resources on doing a second lawsuit? It's like the only time I've ever seen them concerned about the amount of money they were spending. So Your Honor, thank you very much.
Thank you.
Unless you have questions.
I don't, thank you. Ms. Dalton? I need to let counsel know that I have an 11:15 telephonic, so I'm going to interrupt you at 11:15 if you're still addressing the court.
I plan on being brief, Your Honor.
Okay.
I just have a couple of points. First thing that I could do is go back to why we're here. There's a motion to amend the complaint pending. And I would like to, on a more global level, just address the myriad of comments that Mr. Eyman had. This case is all about following the rules, and litigation itself comes with rules, civil rules, the bankruptcy proceeding all comes with rules. And in those proceedings, the court is the check and balance on the conduct of the parties. And all along the way, with respect to the discovery in this case, when summary judgment would be noted, this court and the special master have been involved in those decisions and making those decisions. The appointment of counsel at the bankruptcy court was controlled by the court. That court determined that Mr. Art's initial petition was deficient. That court asked for more, and then that court appointed Mr. Art yesterday. So with respect to all of this, there are rules that apply, and I can't say this without enough importance. The state brings these types of cases, and in this case in particular, where it strongly believes that the rules have been broken, and in this case by the defendants, and where the state found additional evidence of additional breakage of the rules. That is what the state is asking you to amend the complaint concerning. So getting to the merits, I think, is important for everybody. Amending the complaint does not alter the timing of the trial date. The discovery cutoff right now is set for February 12th. The depositions the state has pending now are the same depositions it had pending at the end of November when the bankruptcy was filed. There haven't been any additional depositions. The return on the subpoenas to Beseecum are the same ones that were at that time. So the state wants to get through with discovery, because then the court can turn its attention to making the legal decisions about whether violations have actually occurred. So we're asking you at this time, you've not really been presented anything that would suggest that the standards that you apply when applying Rule 15 have not been complied with, and we would ask that you allow the complaint to be amended.
Thank you.
Thank you.
Court's going to interrupt its ruling at 11:15 because I need to conduct a telephonic hearing at 11:15 with the plaintiff who is in custody. Is Ms. Baber present? Ms. favor for the state? So, the court's also going to rule on the discovery issue as well, without hearing argument from counsel. I mean, no disrespect to either Mr. Eyman or Mr. Seif, but I've read the pleadings, and I was confident yesterday after reading the pleadings and reviewing the entire file which way or what the decision of the court should be, and I remain confident in that decision. With respect to the motion to amend the complaint, the court hears what appears, or how this court has received it, as some sort of maybe inconsistent or unclear, I think is a better way to put it, position on the part of Mr. Eyman. Mr. Eyman, it's clear to the court Mr. Eyman is seeking counsel, or would like at least an opportunity to seek counsel, on the one hand, which is understandable. On the other hand, Mr. Eyman is concerned about further delay in the case, which is also understandable. So, Mr. Eyman, can you tell me what would your position be if the court were to continue the state's motion to amend the complaint for either 1 week or 2 weeks or 3 weeks? Of course, I want to hear from the state with respect to their position on that issue. That a delay or a continuance of this court's ruling would not result in a further delay of the case. In other words, it wouldn't continue the trial date. But I've heard you say that you are concerned, continue to be concerned about how long this case is taking. I want you to know that if the court continues the state's motion to amend the complaint, it would not, that ruling would not result in the case being continued. On the other hand, what I hear you say, at least in part, is judge, make a ruling on this and let's get down the road. So what's your position on that?
My request is that I withdraw my opposition to leave to amend the complaint, add the additional stuff, and have them serve me now, and agree to delay discovery until I can have an opportunity to be able to have an attorney represent me in what will now be a much bigger case, which is preferable to continuing with what we have now and doing a separate one later.
Okay, thank you. I want to make the record clear. The court hears what Mr. Eyman is requesting, in part an oral motion to delay discovery. It's technically not before the court. The state has not had an opportunity to reply, so the court's not going to rule on that motion because it's not present before the court, which is not to say that either or both parties can at any time come back before the court with such a request, of course contingent upon proper notice and opportunity to be heard pursuant to the court rules. So the court will grant the state's motion to amend the complaint. With respect to the discovery issue, and I apologize because I only have 4 minutes now to make the ruling. The court is going to order that the motion to revise the special master ruling be heard by the special master, not as a motion to revise, but as a motion to reconsider. And the reason the court makes that ruling is because Mr. Stipend is the pleading that he submitted in support of his client and in his declaration is making certain representations to the court about comments or assurances that were made by Mr. Eyman's counsel at that time to the special master that are inconsistent with the answers to certain discovery demands in the forms of interrogatories, as I understand them. So rather than parse through all of that, I'm going to order that the special master hear this as a motion to reconsider, because the special master is much more familiar with the facts and is familiar with the representations made by Mr. Eyman's counsel. This court is not. Of course, I wasn't there. With respect to the discrete issue of whether, I'll make sure I'm pronouncing this word correctly because I've looked it up in Black's dictionary. I've never,
Elizor.
Elizor?
It's, no, it's Elizor. You're both wrong. Elizor. The court rules that, overrules the special master on that issue, and Elizor is a person or an entity appointed by the court, and there's no such appointment made, so the court will not allow the signature of an Elizor on any answers to discovery.
Is there any chance you could just translate what that last thing was, what you just did? Well, you can't give me legal counsel, never mind. All right,
No, the answer is, if you're asking me what I just did, there's a motion from the state to overrule or to revise the ruling from the special discovery master.
And what was it? What was his ruling that you just overruled?
I didn't, the only ruling that I overruled was that any answers to requests for discovery must be signed by you or any other named defendant, and Elizor is not proper. It might take a while for the parties to draft up order or an order, and I need to hear, I'm at it now at 11:15, although plaintiff's counsel is not present.
Are you doing that in the courtroom?
I am right now.
Okay. So we do have an order on the motion to amend.
Okay, why don't you share that with Mr. Eyman for his perusal?
Okay.
You don't have to even sign it, Mr. Eyman. I'm not requiring you to sign that order. And in fact, I would ask that you not, if it doesn't make sense to you.
And
I just want to make certain that you've had an opportunity to look at it.
an opportunity to look at it.
Okay.
And the ruling is that the Tim Eyman Watchdog for Taxpayers LLC can't plead fifth. Is that the order that is, or is this a different one?
That's a different one.
That's a different one.
Okay.
And the order of the court in that particular situation is the matter is going back to the special master
Yes.
for reconsideration, so he's not ruling on that issue. Right, Ryan?
Correct.
Okay.
Well, that's one of the issues, as I understand the plans.
Oh, wait a minute.
This is the legal man.
Yes,
That is the legal
yes, good, good. Please give me the
And this is the which one?
motion.
This is the legal man. Okay.
Do you want to see it?
It's the legal man.
Okay, well, let's cross out this stuff. Just put it in. So that's the So I'm handing out to you, Your Honor, the motion for leave to amend, and I believe at this point Mr. Eyman has signed it.
Okay.
And they're discussing the second order now.
Okay.
This decision's here. And self-considered says that this motion is to be considered special master and submission to be considered, which is what he said. And then it's where it goes to the advisor part. So,
I have no idea what that means, so yeah, I'll do that without signature.
Mr. Sykes?
Yes, so Your Honor, I have a draft order relating to the discovery motion that I've shown to Mr. Eyman. And I'm going to present it. One issue I did want to bring to your attention about the special discovery master is that because of the bankruptcy, his bills may not be paid
Oh.
by the defendant. And that can be an issue going forward. Obviously, the state is paying its part of it, but the special discovery master hasn't raised it yet. We have filed some things, but that definitely could be an issue going forward, and I wanted to bring that to your attention.
Thank you.
There's a link online. So I just emailed you. So, I think we'll do that.
Mr. Sykes, I'll need your signature.
Oh, yes, of course. Sorry.
That's okay.
And I'm gonna prepare the legal components.
This